Welcome. Good afternoon. We are here for our part 3 of our summer series on guardianship. And I'd like to thank you all for being here. I see in our attendance we have some of my colleagues and professionals. We have parents and caregivers and some staff from our school as well. So thank you for joining. We will be talking today about the rights of individuals who have a guardian, and our guest today is Dr. Heather Connor from the Center for Guardianship and Excellence. So Heather, I'll turn it over to you, and thanks again for part 3. We're looking forward to today.
Wonderful. Thanks for having me. I'm excited to be here again. Today we're going to talk about the rights of adults with guardians. And just after a little conversation I had with Janine and Anne before we started, I'm going to just let you know about the language I'm using. So I'm saying adults with guardians, I mean anybody who's over the age of 18. And the language we use is very intentional. We used to, in the guardianship world, say things like the ward, or even in Massachusetts, we still use the words incapacitated person. And at the center where I work, we're trying really hard to update some of that language. We want it to be person-centered. We want to make sure that the adult is the focus rather than the disability or the incapacitation. Ward is so institutional. So we're really trying to change some of the language that we're using and focusing on the rights. So the rights is something new in our world, and I'm really excited to be talking to you about it today. So I'm going to go ahead and turn off my video in order to let you focus on the slides, and we will get started. So I'm going to show you this slide here, and I want you to really kind of think about where you are in this journey. You may be a parent of a family member who has a disability. You may be a professional who is working with somebody who has a disability. When you think about where that person is, you know, from a flash, in a flash, they go from being sort of a baby to an adult, and that really passes quickly. So as adults, as parents, we're supposed to sort of let go and let the child grow and be an adult. But I know, and so many of you know, that's a really hard thing to do. And then especially if the child has a disability of some sort, it can be even harder to let go. You have spent that person's entire childhood being a strong advocate. You had to fight for every step of the way to make sure that your child got what they needed. And now you're being told to back off? Well, how the heck do you do that? Especially in the face of others challenging you. So you may be working with a school that says if you want to have any control over your children's decisions, you need to become the guardian. Your child has a disability, you need to become the guardian. So last week we talked about alternatives like supported decision making as a way to avoid guardianship. Because guardianship sort of has a bit of a bad name to it. I'm here to talk about guardianship rights, but in order to do that, I need to talk to you about guardianship overall. So one of the things that we're really trying to do is kind of change the face of guardianship. You heard about Britney Spears, you've heard about the I Care a Lot movie maybe on Netflix. Some of these ideas that the guardian comes in and they take all decision making away from the person and they're in full control. And we're saying, that's not how it has to be. We're saying that the person does maintain rights when they have a guardian, and that the guardian needs to respect those rights. So let's talk about what this looks like. You may know a little bit about guardianship, you may know a lot about guardianship, but guardianship is widely misunderstood. I had a woman when I was first starting guardianship who she is the person I still look back on as really my favorite client. And she said, you know, Heather, when I found out I was getting a guardian, I was scared because I thought guardians were hostile. I thought guardians made all decisions for somebody and that this is, you know, I was going to lose everything. But that's not the way you do guardianship. And that has really stuck with me for a long time. People believe that guardians are going to take over all decisions. I've talked with people with disabilities who said, my guardian told me where I had to put the spices in my cabinet. Well, that's not necessary. That's not important. The person should choose where they want to put their spice. If you want to have your sugar in the second cabinet or the fourth cabinet, that's not up to the guardian. So we need to break down some of these bad images of guardianship that we've heard about. And we also need to know that guardianship may differ depending on where the person lives. So guardianship looks different in Minnesota versus Massachusetts or another state. It also depends on the guardian's knowledge and skills. So we at the Center for Guardianship Excellence do a lot of work on educating guardians because we know that it's a really scary assignment. For those of you who may be the guardian of somebody who's not your child, your biological child, when the court comes and says, thank you for being your neighbor's guardian, that was very kind of you to choose to do that. Good luck. You're like, what? Good luck? I need a class. I need to know how to do this. I don't expect to just have it turned over to me. I had to go to driving school. I had to do all of these other things to learn how to be um, able to do the things that I do in other parts of my life. How am I supposed to know off the top of my head how to be a guardian? So we teach that, and we want to really reinforce that here. One of the things that's important to know is that guardians need support. So in general, guardians who support adults are put in place because because the person is not able to make or communicate decisions. And this could be either because of a temporary or a long-term situation. And the focus here is on decisions. It's not because the person's incapable of caring for themselves. So the person may have physical disabilities, but that doesn't necessarily mean that they can't make their decisions for themselves. So the focus should really be on what the person needs to make decisions about and whether the person has the capacity to do that. There needs to be some sort of assessment. In general, it's a medical assessment that comes up with the conclusion that the person does not have the capacity to make a decision. And there are some documented concerns that show that the person needs decisional support. When the decision is made, the adult has the right to go to court, where the judge will hear all of the evidence and make a decision on whether or not a guardianship is necessary. Guardians are assigned specific powers. And so what we're going to talk about today is that you have a guardianship decree that lays out what you are allowed to do, what the court has granted you the authority to do. And you're really not supposed to do anything beyond that. And we are, as sort of a guardianship world, really interested in trying to limit the authority of the guardian to just the decisions that the person can't make on their own. So if the person needs help with medical decision making, the guardianship could be specifically limited to medical decision making. And that means the guardian has no right to make housing decisions, no right to make decisions about who the person is friends with. So really limiting the guardianship is the best practice in guardianship. It's also limited in the sense that if there's just an emergency situation, a temporary guardianship is very often preferred. So if a person is in a medical emergency and they need a decision made quickly, a temporary guardianship may be put in place. And that way, the guardianship is not any more far-reaching than necessary. When we're talking about guardianship of the person, we're talking about the power to make medical and housing and personal decisions. We are guardian of the estate, which in Massachusetts is called a conservator, focuses on financial decisions. And then in Massachusetts and some other states, a guardian may need special authority to make certain types of decisions. So if you're in Massachusetts, you might be familiar with the Rogers guardianship. A Rogers guardianship gives the guardian authority to make extraordinary medical decisions. Very often that includes antipsychotic medications in Massachusetts, but it can also include other things that are sort of non-reversible. So something like an amputation, certainly a sterilization, Any abortions, things like that would need a certain, another level of authority from the court before the guardian is able to make that decision. So I have on the slide that guardians are decision makers, not caretakers. And this could be different for a family guardian. So maybe the parent is doing both caretaking and decision making. But in general, when I work for Public Guardian Services in Massachusetts, I help out there. When our guardians talk to hospitals and nurse home care agencies and things like that, we say, you know what, the person may need other supports in the home because the guardian is not going to be the one to do their personal care or make the meals or do the transportation or anything like that. That's not the role of the guardian. The guardian is expected to be the decision maker. I might have mentioned last time the National Guardianship Association, and that is the national organization that focuses on best practices for guardianship. And they have created the standards of practice and the ethical principles for guardians to follow. This is really important information because it gives guardians kind of guidelines on how they should be doing guardianship. And I really do encourage guardians to know that information in order to do the best guardianship they can. We at the center do a lot of teaching on the standards of practice and the ethical principles. We have a lot of free classes on ethics. And we do encourage people, like I may have mentioned before, to come to our courses. Our courses are, especially our live ones, are all free. We also have recorded courses. But we have lots of live and free opportunities for you to learn about guardianship, and you can learn about what your job entails and what the best practices for doing guardianship are. I mentioned before when we were talking about the language that we use, that we really focus on person-centered guardianship. And that means the person is at the heart of any decision that's made. And that means that if I am the guardian for three different people, I don't have the same way of handling the guardianship for all three people. It really depends on what the person's needs are and what the person's wants are and what the person's values are. So I'm going to tailor my guardianship to what the person needs and values. Um, we're going to be talking about this quite a bit, but the person should be involved in all of the decisions that are made for them. It's very important to include the person and ask them what they want, what their values are, what their wishes are, so that the guardian can be the advocate. If that's the only thing you learn from me, I'd like you to know that the guardian's role is to advocate for the person. The guardian isn't the boss. The guardian doesn't make the decisions that the guardian would want made. And I think that's very important. I have a family member who has multiple sclerosis and has a lot of restrictions. She's very, very restricted in her life, and recently underwent a cancer diagnosis. And when my cousin, who's her son, had some conversations with her, he realized that what he thought was the right decision was very different than what she thought was the right decision. And thank goodness she was well enough to have that conversation because it's really about what she wants, not what he wants. Um, and so that's really what the focus of guardianship is advocating for the person's wants and needs. And then finally, I want you to know that guardianship is not a lifelong sentence. There are ways to have guardianship terminated and a person's rights restored. And I will let you know that if you're in Massachusetts, there's a process right now that's going through the court to really make this easier so that there's going to be forms available so that somebody can go onto the court's website and figure out exactly what to do in order to get the court to reevaluate their guardianship. So sometimes a person may no longer need a guardian. I have a colleague who had a head injury after an accident, and he had a guardian. And as he recovered from the accident, he was able to recover a lot of his capacity, and he no longer needed a guardian. So he was able to go back to court and have the guardianship overturned. I will let you know that it wasn't that easy. It actually took a lot of work for him to get that done. So the courts in many states are trying to make that process much easier, so that people are able to have their voices heard if they no longer need a guardian. Guardians are monitored by the state and by the state court. And so we are required to submit certain forms to the court on a regular basis. These could be financial forms if we are the guardian of the estate or the conservator. They are person-centered forms if we are the guardian of the person. And they really let the court know what's going on with a person. It also allows the court to know whether or not an expansion of authority might be necessary. Do we need to get more authority for the guardian? Or even better, does the guardian need less authority? Does the person have the ability to regain some of their have they regained some of their capacity and regain some of their authority to make decisions? That's a best case scenario. And courts are open to complaints. So letting the court know if you are unhappy with your guardianship is something that the person has the right to do. The way we do our work at the center is very often through storytelling. And so I want to introduce you to a person. Her name is Rachel, and her story was provided to us by the staff at Perkins. So hopefully some of her story is going to resonate with some of you here on the call. I'm going to let you know a little bit about her. So she is 18 years old. She has an intellectual disability, and she uses assisted technology in the classroom to help her. But recently, due to a degenerative disease, she's lost some of her sight, so she's now considered legally blind. Her school is providing training on 2 life skills that she's going to need, including walking with a cane and reading Braille. The school feels she's capable of learning these 2 skills. In the past, she had a part-time job at a cafe and she was good at it and she was well liked. She had the support of a job coach. She lives with a mom and a dad. She's a single child, but her parents are concerned about her vulnerability. Now, I know as you hear that, you're going to say, every parent is concerned about their child's vulnerability, and they always have been, but they're even more concerned with her sight challenges. So after this, they've been advised to become her legal guardians. So dad started the paperwork, but he hasn't gotten to the part where he needs to present evidence to the court. And I'll remind you from the document we just looked at a minute ago that in order to have a guardianship, there needs to be some sort of evidence that the person lacks capacity in certain areas of their life. So dad is going to need to get this evidence from a doctor. If he's in Massachusetts, she's going to need 3 clinicians. Massachusetts uses what they call a clinician. I'm sorry. What is the form called? Clinical team report. Sorry about that. Massachusetts uses a clinical team report to document the need for guardianship for a person with an intellectual or developmental disability. So she's going to need to have that completed. But mom and dad have not talked to Rachel about what's going on. So they haven't talked to her about their thoughts that she might need a guardian, and they haven't talked to her about the fact that she's going to need to have a medical evaluation. They certainly haven't talked to her about the fact that she has the right to go to the hearing and participate in that hearing. So let's talk a little bit about what's going to happen when they evaluate her decisional capacity. If you were here last week, you may have seen this slide, but I'm just going to review it for those of you who were not here last week. When we're looking at whether a person needs a guardian, we're looking at whether they have capacity to make a decision. So we're focusing on the ability to receive and evaluate information or to make or communicate decisions. Most of us, all of us adults are assumed to have full capacity. And that gives us the legal right to make our own decisions. But when a judge makes a ruling that a person no longer can make or communicate decisions, after the person has been evaluated, after the person has had the opportunity to contest within the court and to attend the hearing, the judge could make a ruling of incapacity. And like I said, that would require some medical evidence. So if you're in Massachusetts, it would require the clinical team report for a person with a developmental or intellectual disability, a medical certificate if you don't have those two issues, and that evidence would be considered by the judge and a ruling would be made. I'll show you the whole kind of pathway towards guardianship. So it starts with somebody identifying the need for a guardian and filing a petition. So this is New Mexico's pathway to guardianship. And in New Mexico, there is a requirement for a petition form, which is available on the court's website, some proof of incapacity, a bond must be filed. So the bond is basically you saying, I am going to do the right thing. I'm not going to, make bad decisions. I'm going to work in the person's best interest. And so that's a form that gets filled out. And then an advance directive. So if the person already has a healthcare proxy, if the person has a living will or anything like that, that would be attached and given to the court. Once that's filed with the court provides citations, which are notifications. There is a process where the person who is thought to need a guardian is given this notification. And then any family members, interested parties that maybe they'll live with a person or anybody like that would be notified that the person has been identified as needing a guardian. It would also give them the information about how to contest the guardianship. So the person has the right to contest the guardianship, the person has the right to go to court and be able to speak up about the guardianship. A hearing will then be scheduled. And in some cases, the proof of incapacity will need to be updated. So for a clinical team report, it's 90 days in Massachusetts. For a medical certificate, it's 30 days. So you'll just have to know whether or not it needs to be updated. New paperwork needs to be brought in. Finally, there's going to be a day in court. And like I said, the person has the right to be there. The person has the right to be heard by the court. Evidence will be reviewed. The medical evidence will be reviewed. Any testimony will be heard, and the judge will make a decision. So the judge will decide whether there is a temporary guardianship, a permanent or long-term guardianship, whether the guardianship is limited or full, or whether no guardianship is needed. And there's going to be a decree that's issued, and that's basically the letter from the court explaining what the guardian's duties are and responsibilities are, so that everybody knows what it is that the guardian can and cannot do. So getting back to Rachel, Rachel's parents have some concerns, and they're both mostly focused on money management and medical decisions. So, like many parents, Rachel's parents are concerned that she's not going to be proficient with banking or spending money the right way. And they're hoping that the guardianship is going to give them the authority to manage her money. But they say they're going to include her in the decisions. They're also concerned with some things that she's said recently. She's made some remarks about being done with doctors. So they're wanting to have some authority over medical decision making. So now comes the question, how can her parents meet their goals to be guardians, protect Rachel, help her participate in decisions, and support her independence all at the same time? And so what I'm going to say is that understanding the rights of the adult with the guardian, figuring out what to do with that information, and figuring out how to carry that out is going to really be the key to this question. So let me show you a couple tools that we use to lay out the rights of the adult with a guardian. On the left, you're going to see a tool that the center created that lays out the rights of adults with guardians. It's 8 categories of rights. And when we created this tool, we were trying to figure out what areas of life a guardian might be involved in. And really, where did the person maintain their rights? How did the person maintain their rights? And we wanted to make it as simple as possible. There are some tools that are very, very complicated, but we wanted to be able to put something on a bulletin board and remind the guardian, but also remind the individual who has the guardian what their rights are. The second tool that's on the right is the Bill of Rights for adults who have guardians. Now you'll notice that that's a lot more than 8 things. There are a lot of rights, which is wonderful, and it's a new and powerful tool. This is a brand new tool. It was only created in 2021, and I'm excited that it exists. But there are pros and cons to each of these tools that I'm going to talk to you about. So we're going to start with the Bill of Rights, and we'll come back to the graphic after that. I mentioned that the Bill of Rights is new. So in 2021, the National Guardianship Summit, which the summits are held every 10 years. This was held at Syracuse University Law School. And when they're held, they bring together scholars on guardianship, people who practice guardianship, lawyers, doctors, people who have guardians, people who work in the aging and the disability fields, people who could be subject to a guardianship. So lots of people who are affected by the guardianship world. They all come together and make recommendations for the next 10 years of guardianship work. And their recommendations are really kind of the pathway for what we should all be working on in the next 10 years. I'm really excited that the very first recommendation to come out of the 2021 summit was that we should create a Bill of Rights for people with guardians. And I was so honored to have had the opportunity to be a member of the task force that built the Bill of Rights. So our task force committee included, again, people in the aging world, in the disability world, people who have been guardians, people who have had a guardian. So I mentioned a colleague who had had a brain injury and he had had a guardian and no longer needed the guardian. He was on that committee. So people who really had lots of opportunity to see the ins and outs of guardianship got to create this tool. So we reviewed other bills of rights that existed in other states. We looked at literature, we looked at state laws, all different things to come up with our tool. And when we were doing it, we were really trying to think about, we could make it as legalese as possible if we wanted to, but we wanted to make it as plain language as possible so that people with disabilities might be able to read it and understand it so that they would know what their rights are. The document was approved by the National Guardianship Network and is now available for the courts and guardians and organizations to use. The Bill of Rights has 5 parts listed here: access to justice rights, core human rights, decision-making rights, the guardian's authority, and restrictions. So we're going to look at each part of this document. And I'm going to, you also can see on the side, there's a QR code if you'd like to download it. So the whole document is available from our website to download. So I'll just give you 1 second in case you're going to grab that QR code. So even though this is the end of the document, I'm going to start with the end, and the end focuses on restrictions. The court may restrict one or more of these rights that are listed on your slide, but only with due process. And so when we're talking about due process, basically we're talking about fairness. Throughout US history, the Constitution, state laws, case law, they've all provided standards for fair treatment of people at the state and the federal and the local levels. And so really when we're talking about due process, we're talking about how the court puts processes in place to make things fair. So the only rights that can be restricted with due process are the right to apply for or maintain driver's license, to be educated, to be employed, to communicate and interact with others, to change your marital status, maintain your reproductive health and procreation, to travel, and to vote. And so these restrictions are so big that only with court authority is the guardian able to put those in place. So I'm going to ask you for a minute, thinking about Rachel, who I introduced to you a moment ago. What do you think the court might decide to restrict on this list? If you put it into the chat, that would be great. Which of these might the court decide to restrict? I'm seeing in the chat that the QR code doesn't take me to download the document. I apologize. I will make sure that the Perkins staff gets a link to it after this seminar, and I will make sure that you get access to that. But thank you for putting it out. So I'm seeing a couple people in the chat saying the license due to vision impairment. I think that's the only one that I see based on the information that we know about Rachel that the court's likely to restrict. So that is really important. So other than that, the court should not be saying anything about her right to be educated, about her right to be employed. Excuse me. She should be able to make decisions about her marital status and her reproductive health and procreation. She should be able to travel and vote. All of these things should be allowed to her based on the situation that we know about her so far. This section of the Bill of Rights clarifies what guardians can be authorized to do by the court, but again, only with due process. So only with the fair rules in place that the court has put in situations. So if you're a guardian, it's essential that the person know which of these assignments has been given to you. So I'm looking at the chat here. The language of the New York State Guardianship Decree is only boilerplate. It does not customize rights this way. We have completed the process. I know that, and so that's really interesting. Although the Bill of Rights has been agreed upon by the National Guardianship Association and by the American Bar Association and some other groups that advocate for people with disabilities. It has not been uptaken by all of the states yet. So we are encouraging states to take this up. Right now, we are doing a lot of advocacy around that so that states decide to take on the Bill of Rights. But that doesn't mean that the guardian shouldn't be making sure the person still has these rights and are given these rights. So the guardian can act even though the law hasn't come up to date yet. Okay, so if you're the guardian, it's important for you to have a conversation with the person you're guardian for in order to talk about what rights have been given to you. So have you been given the right to acquire the benefits and supports and services for the person? Have you been given the right to consent to or refuse medical and mental health treatment, determine where the person lives, determine the social environment and social aspects of the person's life, file and defend lawsuits, make contracts, make gifts of the person's money, manage your money and property? These ones should be very specifically laid out in the guardianship decree. And this can be a really helpful tool when you're sitting down with the person. So being able to say to the person, I know you have some questions about the guardianship. And maybe like the person that I mentioned earlier, maybe you've heard that guardians are hostile and you're nervous about what's going on here. Let's have a conversation about your rights. I want to uphold your rights in every way possible. So I'm going to introduce you to a new document called the Bill of Rights for Adults with Guardians. Would you like to hear about it? And this could be a really great entry into letting the person know that you're not going to be hostile. You're not going to take over and make all of the decisions for the person. You're going to encourage the person to be involved in all of the decisions they can, to whatever extent they want to be. When we're talking about access to justice rights, we're talking about access to the court. So a person with a guardian has the right to be seen and heard by the court. And this starts even before the guardianship is granted. But basically, the person should know, the guardian should know that they should not be making any decisions that have not been listed in their guardianship decree. And I remember what a change has been made. So I was a guardianship intern back in probably 2000, 1999 and 2000. And I remember being told, oh my goodness, we are a limited guardian of this person, and it's so annoying. It's so much easier to just know that you can make all of the decisions for the person rather than having to go back and look at the decree and da 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 da. And I remember thinking at the time, well, that's not very, I didn't know the language, but I should have said that's not very person-centered. That's very, that's very convenient for the guardian, but it's not about the person and what the person wants. And so I'm really excited that we've come now to learn or to believe that a limited guardianship is the preference, and that we should only be focusing on the rights that the court has granted to the guardian when we're making decisions. The person with a guardian has the right to hire a lawyer who advocates for the outcome that they want, not necessarily what's in the best interest of the person, but the outcome that they want. The person with a guardian has the right to be present and participate in court hearings. They have the right to tell the court their concerns and their complaints about the guardianship. So they have the right to say, I don't want this person to be my guardian. And I remember with the Britney Spears testimony after during her guardianship hearings, she was saying, I didn't want my father to be my guardian, but I didn't know I had a right to be heard. I didn't know I had a right to request that somebody else be my guardian. And I remember at that time, this was before the Bill of Rights came out, I remember thinking, oh my goodness, we have a problem here. If people don't know that they have the right to be heard by the court, we're doing something wrong. And so I certainly know that Brittany was hopefully a real one-off, and that's not how most guardianships operate. But I don't know that all guardians really said to people, you have the right to be heard by the court. That's something that maybe guardians weren't aware of or wasn't on their radar. So when you can tell the court about your concerns, you also have the right to ask the court to review your guardianship for changes. So maybe say, you know what, I've gone to school, I've done a lot of work, and now I no longer need help with bill paying. I'm able to manage my own bills. So could you please limit my guardianship to allow me to pay my own bills? And that's definitely something the court can consider and do. The right to evaluate, to have an evaluation done of what you can do and if you should have some of your rights restored. So there are professionals that can do evaluations of a person's skills. The right to have support and accommodations in order for the person to effectively communicate with the court. And right to have your rights explained in the preferred method of communication and in the language that you choose. So this is very person-centered. This is really focused on what the person can do. Then we move on to core human rights. I'll tell you, one of my colleagues has a real problem with the dignity and respect phrase because she says, what does that even mean? It means something different to everybody. And so we have a lot of conversations in our world about what does it mean to be a guardian and treat somebody with dignity and respect. Basically, we're talking about having the person live their best, most independent life. So not being shamed, not being criticized, not being ignored. are ways that we tend to think about dignity and respect. Abuse, neglect, and exploitation may seem obvious to you, but the Bill of Rights also says that the adult can't be discriminated against. On the one hand, this is like everybody else. We have the right to needed services and treatments. But as you may know, people with disabilities tend to receive poor outcomes in the medical world, in the banking world. They tend to be, have you ever been with a person with a disability and had the doctor speak to you instead of that individual? I don't know if your child might have a disability and the doctor says, so what are his symptoms? And you'll say, talk to him. He's the one with the symptoms. So people experience bias. They experience, reluctance to offer certain solutions based on their status or their capabilities. So this really helps remind the guardian that we need to advocate for the person to not be discriminated against, to be given as many opportunities as somebody who doesn't have a disability. So the right to be as independent as possible. So, it may be a lot easier to find, a group home for somebody with a disability and know that they have 24/7 supervision. But if the person has the capacity to live more independently or in a group living situation with other adults, that could be a really good opportunity for the person to grow. And as we said last week in the supported decision-making discussion, we all grow and learn based on trying new things and making mistakes. So I do encourage you to let people kind of make mistakes and let people learn and grow. Because even though it can be scary, it can be a really good learning experience and growing experience. And I can see there's something in the chat, but I actually can't access the chat right now. Hold on a second. I'm gonna have to wait until it pops back up again. It's not letting me into it. The right to express and practice your religion, the right to personal privacy, the right to a humane, safe, sanitary learning and working environment, right to sexual expression and to gender identity. Those are two different things, but they're kind of grouped together in the Bill of Rights. And I encourage you to recognize that the person has the right to their own identity, and that shouldn't be determined or explained by the guardian. And finally, the person has the right to a competent guardian who advocates for the goals, needs, and preferences of the person, including their medical preferences, their cultural practices, and their religious beliefs. I'll remind you again that I said earlier that the guardian should be the advocate for the person's goals, needs, and preferences. So that should be really what the focus is on in guardianship. When we're talking about decision-making rights, we're talking about the right to be a full participant in decision-making, especially in where you live, the type of care you're getting, social interactions. And we made a decision to explain this. So it's to the extent you wish to be involved and are able to be involved. And it started originally with just are able to be involved. But there are some people who say, I'm not comfortable making these decisions. And while that's a learning opportunity, it's good for the guardian to encourage somebody to try to make decisions and become as independent as possible. If the person really doesn't want to, they shouldn't be forced. So that's important too. Least restrictive opportunity. Oh, good. There's the chat again. Hold on. So the question is, would the individual identified be appointed an attorney by the court, or would this be out of pocket in Massachusetts? In Massachusetts, the person, if they do not have resources, they would be paid for by the court. If the person has financial resources, then they would be expected to pay for their own attorney. And there is no required training in Massachusetts to be a guardian. There's going to be some videos that are going to be available on the court's website starting, I think, in this maybe fall, that are going to be kind of short videos that talk a little bit about guardianship and reporting requirements, but there is no required training. I will let you know that in Massachusetts, that here at the Center for Guardianship Excellence, we offer free training, and we do encourage you to take the training, but it's not required. So people have the right to receive needed services in rehab within available resources in the least restrictive condition. So it shouldn't always be in a nursing home. And there's actually a lawsuit that's just being kind of worked out. It's a the Marster, I think, hearing decision that is just coming out now, and it's really being considered by Massachusetts, the state of Massachusetts, to try to get people out of nursing homes, because so many people are only able to get the kind of care they need, especially older adults, but certainly younger people with disabilities, if they're in residential settings. And so the move is to try to create more community settings in order to help people live in the least restrictive option that they can. So that's exciting. That's going to be taking the next 8 years or so to really fully come into fruition. But the goal is to get people into the community whenever possible. The right to have the guardian prudently manage your resources, right to fully participate in decisions about how the property is managed, again, to the extent that you wish to involve and are able to be. And then the confidentiality. It's very important that the guardian keeps confidential the matters that you want them to keep confidential. And that doesn't include, so the guardian can certainly, if there's concerns about abuse or neglect or exploitation, the guardian can let the proper authorities know. But otherwise, they shouldn't be talking about your issues with your family if you don't want them talking to your family, or with their friends or other people. It should be important to keep that information private. So I'm in Massachusetts, but I have a colleague who's in Minnesota. And one of the requirements in Minnesota is that you check in with the person about the Bill of Rights on a yearly basis. And I think this is such a cool requirement. So you have to say to the person, let's look back on the past year and the decisions we've made for you. Let's make sure that we review your legal rights so you can see what I've been doing and what we need to do next. And I think that is a great opportunity to remind people that they have rights, to keep the rights on the forefront of everybody's mind, and make sure that the guardian is doing what it is that the person wants them to do. The Bill of Rights is also a good way to keep other people involved. So keeping the family involved. When the family says, I don't know why. So I have a client right now, for example, the family really wants her to go on vacation to Panama. And she said the client does not want to go on vacation. She's very happy where she is. She doesn't want to travel. It really kind of stresses her out to be around her family. They're not people that she's really comfortable with. And so I have been fighting with this family and saying, your aunt doesn't want to travel. And there have been protections that have been put in place. The court has assigned me responsibilities that I am obligated to fulfill. Her wishes have to be my top priority. And I understand that you want something different than she does, but her wishes are my top priority. And that's sometimes a helpful way of reframing things when we're talking to family members or other people who are interested, who have a different idea of how we should proceed. Making sure that we remember and help to be reminded that the person's wishes are forefront. This is something we can also do for other providers. So if we are having a back and forth with a group home or somebody else, being able to say, you know what, my client has specific areas of concern that she and I have put in place. Let's talk about ways to make sure that her rights are focused, and we are upholding those rights as much as possible. And then finally, this is a good opportunity to look for ways to limit the guardianship. So, you know what? These are the restrictions in the guardianship decree. If they no longer seem appropriate based on the job training that you've been doing and the education that you've been doing and sort of the maybe whatever therapies and your own physical improvement, mental improvement after your injury, whatever it might be, let's look at these at these rights that were taken away from you and see if we can go back to court and have them reviewed. So I think it's a really good tool and a good practice to go back and review people's guardianship decrees on a very regular basis to make sure that there aren't places, or see if there are places that the guardianship can be limited. So I mentioned before that before the Bill of Rights was created, my team was looking for ways to really look at the rights of people with guardians. And I think this all came about around the Britney Spears situation when she didn't know that she had the right to go to court. So we identified some areas of decision making that the person really retains rights. We wanted to make this, like I said, as simple as possible so that they're able to kind of put it on your bulletin board and remember, I have the right to be involved in my decision making. And that means that the person should ask me my opinions. The guardian should ask for what my wishes are, ask me my values, do all sorts of different assessments in order to make sure that my voice is heard when a decision is being made. Going back to privacy, the guardian doesn't have the right to read my emails. The guardian doesn't have the right to take the door off of my room so that I can be seen at all times. I have the right to have privacy. Again, protection from discrimination. The guardian has to really be active in making sure that I am not being discriminated against. And that if I have a legal question, I have access to legal advice. So this goes to the question that was asked in the chat a couple of minutes ago. The person does have the right to legal counsel in most states. There are some states where there is not a right to legal counsel and you have to ask for legal counsel. Freedom of religious expression. And that means that the person may choose a different religion than the one that they grew up in. And that is their right to be able to do that. Freedom of love, sexual expression, and procreation. Safe, sanitary living and working environments. And then the right to have needed services provided. So let's see if we can apply this for just a couple minutes. And I know we're heading towards the end of our hour together. So I'm going to ask you to put in the chat, if Rachel, our friend from before, asks her gynecologist for birth control pills and the doctor tells her parents, which of her rights are being kind of trampled on here? Medical privacy. Thank you. There's also a possibility that maybe her access to needed services, maybe she's needs services that are not being given to her because her privacy is being overstepped on. So Rachel and her friends have applied for 3 apartments in the community and they've been told that they're no longer available. Is the guardian going to be looking out for any of these areas? I think in the interest of time, I'm going to answer my own questions. So I apologize if you can just answer them in your head. So if my client has told me that they have applied for 3 apartments in the community, every time they apply for an apartment, they're being told that there's no available apartments there. I'm going to be a little bit worried about discrimination. I'm going to be really looking into that. I'm going to be making sure that they're getting a safe, sanitary living and working environment. And I'm going to make sure that she's involved in all of the decisions that we need. So if we can involve her in decision making, that's going to be important. There may also be a situation where I need legal advice in this. So if I need to get access to an attorney, I'm going to look into that too. If Rachel refuses to attend religious services that she used to love, now she wants to be with her friends during that time instead of her parents, she has the right to freedom of religious expression. So that means she can choose not to be religiously involved if that's her choice as well. And that should be something that the guardian upholds. And then finally, later on in the future, if she chooses to marry somebody that she's been dating for 6 years, that's going to give the guardian the opportunity to look into her freedom of love and sexual expression, her participation in decision making, as well as her privacy. So people with guardians can certainly still get married. The question here is it possible for guardianship and preservation of human rights to effectively coexist? And I am going to tell you a resounding yes. Guardianship can have a powerful role in the lives of so many people. When the guardian genuinely loves and supports the person and follows the rules for effective guardians, the results can be so successful. We see outcomes like people leaving group homes and moving into shared housing with their roommates, or people meeting, dating, and marrying partners, people living with as much independence as they can manage. When guardians uphold the Bill of Rights and the rights of people with guardians, that can really lead to a very happy person. So my final thoughts for you as we are ending this hour together. Protecting the rights of adults needing decisional support is so important. And you can do that when you look at the rights of people with guardians. It's important to help the person with the guardian understand their rights and your role as the guardian. You're not the boss, you're the advocate. And then finally, you can download our free infographics and you can share them. I will, like I said, get those links back over to the Perkins team so that you have access to those. And I just want to share one last slide with you before I let Perkins take over. And that is to let you know that if there are other things that you would like to learn about, we encourage you to come to the center. Like I said, all of our training is available for you. It's free. You can sign up. We have 10 or 12 people signing up every week. So we have a really active group of people who are involved in our training. We have things to take on demand. So if you can only do it at night or on the weekends, that's available to you as well. We have support groups, we have listening opportunities. So please enjoy what we have to offer and let us help you be really effective in your roles. So I'm going to pass this back on to Anne over at Perkins. So thank you for letting me speak today.
Thank you, Heather. I learned so much. It was such an amazing presentation today. If you have any questions last minute, please put them in the chat. It's been a really amazing presentation. And I put next week, we have our last series. And you have been appointed guardian, now what? So I'm looking forward to that dialogue. Just a couple of notes that we wanted to share again, that we do have a one-on-one transition counseling service available to you. So if you're interested, our contact information is on the last slide where you can reach out to us. And it's highly individual and really looking at a holistic view of your adult child or family member or client. And, in addition to what Heather is offering, free resources through the Center for Guardianship and Excellence is just so valuable. And here's our team with our contact information. And thank you, Janine, for the slide deck support, and Alex Lavoy, our director, who's on today. If you have general questions, transition@perkins.org. And I think there's one more slide. No, I guess not.
I
We do
missed this one. I'm sorry.
Oh, yes. Thank you so much. We do have a Facebook group. It's called Transition Talks. And when you get your slide, you can click on that, or maybe Janine and Alex can put the link in because we just have another few seconds. And thank you so, so much, everybody. We will see you next week.
Thanks, everybody.